Well, first of all, while we wait for the slides, let me thank you for having the opportunity of giving you this presentation. Oh, okay, here they are. We have just heard about the advantage of cloud. And cloud is an online territory, as we have started saying, as the title of the session is. It has great operational advantages. The digitalization is one of the very big points of clouds, that you can be everywhere and operate on everywhere else and use this data for in whatever region you want. But as usual with lawyers, from a legal point of view, this poses a lot of issues concerning applicable law, kind of law, criteria of interpretation. Now, and this may lead then to the fragmentation of what by itself, by its technical standing, would be a single world market, an all-land economy and market. There are many reasons for this. Different national legal frameworks, uncertainty of applicable law, different interpretation of basic rights. Now, in my presentation, I want basically to tackle three issues. Give you a few hints about some specific issues concerning contracts and its interpretations, which is different in different jurisdictions. And then come to the issue of data protection, which has been recently highlighted by a European Court of Judgment decision on the 6th of October, so a few days ago, which risks having big impact on jeopardizing the cloud system. And finally, a few hints about competition law, which is also, and how competition law may or may not affect the cloud economy. The basic risk of all this, of the developments we are going to analyze, is that uncertainty hampers exploitation of potential benefits. And this may affect both the way the market and the system will develop, and will particularly affect the use of these potential benefits by small and medium enterprises, which may be less equipped than large ones. Now, as for contractual issues, there is no specific cloud law, there is no specific cloud contract. So key contractual issues depend on national laws and their interpretation. Here I listed a few issues, but there are a number of others, obviously. First of all, what are the performance obligations stemming from service level agreements, which are qualified in different ways according to different legal systems? What is the possibility of limiting liability for indemnification in the use of clouds, of data on clouds, and eventually faults? Usually limitations on liability are admissible, but in many jurisdictions, for instance, there are limits to the limitations, both for B2B contracts as to B2C cases. In particular, consumer protection implies a strong protection of individual customers, and in some countries, consumer protection is extended to small business. So all this obviously creates issue for those who operate in the field and for those who want to use the system, the clouds, and therefore there's a quest for standardization and harmonization, which comes both from the industry itself through industry initiatives, like I was quoting here a case in Sweden where the industries elaborated general terms of cloud computing, which are obviously voluntary according to who agrees to them. And then instead, wider publicly sponsored initiatives for standardization, in Europe in particular, the Commission is elaborating safe and fair contract terms and conditions through regulation, which enters into the cloud initiative, Safe Cloud Initiative, which I'll just come back at the end of the presentation. Then we have the issue of privacy, which has become which has come on the news in the last few weeks. Basically, obviously, we said the cloud is an land economy, but various territories have their own laws concerning how you can use what is the raw the raw element for clouds, which is the data. Data protection law is different in different territories, is different in the EU and is different in the US. The US was the first country where privacy issues were raised at the end of the 19th century. But the way in which privacy is seen in the United States is different from the way in which privacy is seen in Europe, where privacy is a fundamental right of the individual guaranteed by the European Charter of Human Rights, and therefore is a right which must be protected, and there are limits to the way in which this privacy may be restricted. The cloud computing, being basically an online territory, poses the problem of whether the regulation, the internal treatment of data, where the data is processed, is compatible with the law of the place where the data is formed. And a study by Sky High Networks a few months ago showed what tried to estimate where the EU personal data was stored, in which, and apparently about 65% of the data was stored in systems which were not compliant with the EU regulation. In addition, 17% were hosted in the United States under a safe harbor program, which we are going to see in a minute. And this is what the fact that that there is a difference between between privacy rules in Europe and privacy rule in the United States and in other places is something which may affect then the distribution, the way in which the whole system or the whole cloud system will develop in the future. You all know that in Europe, since 1995, there is a directive protective privacy protective privacy and therefore data. The directive is of 1995, so there was little cloud computing at the time. Actually, there was no. So the directive has been extended by interpretation to cloud services considered to be processor or sub-processor of data, which would be affected by the directive. The directive states a very high standard based on personal rights to privacy, and therefore it requires that treatment of data is made according to certain principles. And the new regulation, the Commission is now working to a new regulation, which will be issued in 2017, which has been already examined by Council and the Parliament. This is a regulation, so will affect throughout Europe without the need to come into national legislation, and will explicitly apply to cloud services. So we can say that cloud services is directly affected indirectly by the directive, by interpretation in the directive, directly by the new regulation, and therefore now in order to the problem is then for systems, cloud systems which are set into the European Union must comply to the regulation. What about systems which are outside the European Union? Well, in such a case, the system may still host European data as long as they are compatible with with the rules set in Europe, and it is the Commission which evaluates whether this is the case. And the Commission decision has examined a number of data treatment in other jurisdictions. Some has approved, and in particular, you know that in 2000, it made a decision concerning the safe harbor principles regulating regulating the data collection in the United States, and it decided that it was at the same level, it guaranteed the same level of protection than in Europe. But the judgment of the 6th of October concerning the transfer of data from Facebook Irish subsidiary to a data center in the United States stated that, first of all, the Commission decision is not binding on national data processing authorities to evaluate whether the degree of safety is actually, was actually compliant, despite the Commission decision has said that it was. And secondly, that in any case, the safe harbor principles were not compliant because the standard of protection, because the public sector bodies, you know the NSA case, had in any case access to the data, despite the companies could treating the data, were guaranteeing compliance to the safe harbor principles. Therefore, what does it mean? Well, it means that the transfer of data to processors in the United States is jeopardized. What are the remedies? One possibility is contractual guarantees to privacy. This is, since particularly the safe harbor principles have been considered as too lenient already, there was a lot of criticism about them, already starting in 2004 and then later in 2010, and then in an opinion of the Working Party, which is the gathering of all the data processing authority in Europe, stated some standard clauses which included in the contract could guarantee the compliance of treatment of data by companies. And in fact, starting in 2014, some companies were able to obtain individual opinion of compliance. Obviously, this helped. But it doesn't help with respect to the public body access to data and on the guarantees of the EU citizens. So the problem is really there is an imbalance between data protection in the EU, therefore incentives to set data center in the EU, and instead the level of guarantee outside, and in the specific case, in the US. Now, this problem with the US could be solved over time if the umbrella agreement, which provides for judicial redress for EU citizens in the US under preoccupation for criminal law, but could help in this case as well, is approved. The problem is the process of approval is still ongoing. The US must still approve the text as it was redacted, then the Commission, it will probably take a little time. Having therefore discussed the privacy, I just want to go very shortly to the issue of big data, because the treatment of big data and indirectly the issue of clouds is of interest of Antitrust Authority. Basically, the idea data are gold because they are used for many purposes. Who controls the data may use it for his competitive advantage and may exclude competitors. This is basically the idea under the Google procedure ongoing at the Commission, but just a couple of days ago, the French and German competition authorities opened a joint study on new challenges and risks posed by big data. So it's a problem, it's an issue which has been discussed among the competition authorities. What are the basic points? Well, the strengthening of market power through locking effects. So here an issue which is, in a sense, the issue of standardization and interoperability is of switching costs. We may see it from a legal point of view, we may see it from an antitrust point of view. The risk of tying that cloud providers, particularly when they are vertically integrated, may push their clients to use also services which they could acquire from other suppliers. and the risk of raising barrier to entry once you have got to a very large position. Okay, I just want to end just quoting what I was mentioning before. Obviously here we have issues of standardization of terms and conditions for providing the service, standards, interoperability. There is a European project to tackle this problem. The European Commission will present in 2016 the European Cloud Initiative. The idea is to ensure as much as possible interoperability and possibility of switching from one provider to another. The big issue is how will this affect the relation between the EU cloud system and the no-land economy characteristic of the cloud system. Thank you.